Fun stuff.
We can get to the fun stuff. Happy to introduce Josh Blackman today. Josh is an associate professor of law at South Texas. He is very impressive for a man of his age, the author of 3 books and many, many articles. But the books are Unprecedented, The Constitutional Challenge to Obamacare, Unraveled, Obamacare, Religious Liberty and Executive Power, and an introduction to constitutional law, 100 Supreme Court cases everyone should know. Josh was selected by Forbes magazine for the 30 Under 30 in Law and Policy. He's twice testified before the House Judiciary Committee. He is the founder and president of the Harlan Institute, the founder of Fantasy SCOTUS, the Internet's premier Supreme Court Fantasy League.
You should all play.
And blogs at joshblackman.com. He's written over 4 dozen law review articles, in addition to many, many articles, including one today published in the New York Times. And so I'd like you all to welcome our speaker, Josh Blackman, who will be speaking on impeachment and the Constitution. Very kindly.
Thank you so much. Can you all hear me okay? Okay, great. It's a pleasure to be here in Houston. Usually I have to get on a plane to speak somewhere. Now I'm about 5 blocks from my law school in South Texas. I have class at 2. Today we are covering oil and gas and property, so much more dry, or maybe wet, I don't know how you describe it, but this is a fun topic. Not at all relevant, of course, which is impeachment. Let's start with a show of hands. Who here has watched any of the impeachment trial the last 3 days? More than an hour, more than 2 hours, more than 3 hours. How much have you watched? A lot. I've watched maybe 5 or 6 hours, and to be frank, I've turned it off. So I will do my best to summarize what's been, at this juncture, nearly 20 something hours of proceedings, but I'll do my best. Also, I'll do my best to do this as neutrally as I can. Impeachment is one of those topics that is divisive by its very nature. And people have strong, well-held, and I think well-founded positions on this, depending on their position. I'm not trying to persuade you on anything, but I'm going to do my best to walk you through what the title of the talk is, Impeachment and the Constitution. So let's start with the basics. The Constitution has a process by which certain positions can be removed from office before an election. The President, the Vice President, and also civil officers of the United States. What are the grounds on which a person can be impeached? The Constitution lists 3 categories: treason, bribery, or other high crimes and misdemeanors. Until this year, we've had 2 impeached presidents, Andrew Johnson in 1868 and Bill Clinton in 1998. Both were acquitted in the Senate, and they finished their terms in office. Richard Nixon resigned from office in '74 before he was impeached, so that doesn't technically count as an impeachment, but it got awfully close to an impeachment. It would have been if he failed to resign. But now we have number 3. President Trump has now been impeached, and as we speak right here, a trial is ongoing. We probably just put CNN in the background so you could watch it, but this is ongoing. Let's start with some basics. The term high crimes and misdemeanors, what does this term mean? Books and books have been written about it. But at a very high level, this term comes from the British common law tradition. It was a sort of offense that Parliament cited when they removed certain crown officials, and this has been known for hundreds of years. It can mean some sort of abuse of power. I use that phrase very lightly. Some sort of abuse of power by some high-level position. At least in the English system, it did not require a violation of any ordinary criminal statute, and I think that's the position in the United States as well. Alexander Hamilton in the Federalist, for example, described the crime as those offenses which proceed from misconduct of public men, or in other words, from the abuse or violation of some public trust. They are of a nature which may with peculiar propriety be denominated political, as they relate chiefly to injuries done immediately to the society itself. Now, that's a very broad definition of possible offenses, at least according to Hamilton. What is the process? pretty straightforward, at least on paper. The first step is the House votes on articles of impeachment, and the second step is the Senate holds a trial. To approve articles of impeachment, you need a simple majority of the House. To convict or remove a president or any official, you need a 2/3 vote in the Senate. We have two prior incidents. In 1868, the House approved 11 articles of impeachment against President Johnson. They mostly concerned Reconstruction and his refusal to prosecute it. But probably the most significant one was the Tenure of Office Act. This law limited the president's power to fire certain cabinet officials. President Johnson fired Stanton, who was Lincoln's Secretary of War, and the Congress impeached him for it. Now, actually, I think Johnson was right. I think the statute was unconstitutional, as time would tell. Fast forward 130 years, the House approved two articles of impeachment against President Clinton. The first was perjury. They lied in a grand jury testimony concerning, of course, his relationship with Monica Lewinsky. The second offense was known as obstruction of justice, something that lawyers know about quite well. They attempted to hide evidence in that case. Okay? Now, both perjury and obstruction are standalone criminal offenses in any jurisdiction you can find. In both the Nixon and Clinton cases, the House Judiciary Committee held an investigation and recommended articles to the full House. But I don't know that that's required. Indeed, the House could simply just vote on the floor without a committee vetting them. This actually matters of how you get to the final goal of impeachment. All that I think is actually required is at some point, somewhere in the process, the House approves the articles, and at that point, the House managers literally walk the articles over to the Senate. Did you watch that video? It's very somber. They're walking like this, right? Very, very dramatic. They can't just text it. They have to literally walk the articles over, and it's that transmission that initiates the process of the impeachment trial. Once it gets to the Senate sets their own rules of proceeding. Like with anything else in the Senate, usually a simple majority is sufficient to change the rules. Presidential impeachment, though, varies in one important regard. Usually with impeachment, the vice president presides. The vice president is the president of the Senate. But for a very good reason, the vice president does not preside at a presidential impeachment. Why? If the president is removed, who becomes the president? The VP, right? So it would be nuts to allow the vice president to sit as a presiding officer for the presidential impeachment. So the framers added the Chief Justice to sit in that role. But fun fact, what if you impeach the vice president? Who presides at that trial? The vice president. Talk about that another time. One of these fun constitutional riddles. That's the rules. That's the rules. He would have to sit there. This is actually not insane. Thomas Jefferson, when he was vice president, was the president of the Senate. And in the disputed election of 1800, he counted his own electoral votes. And there's some argument that there were some records from various states that weren't clear. He may have counted them not the best way. So this is not fictitious, right? Right. Remember, this was an election that tied in the Electoral College, and there's some evidence that maybe some of the votes were a little bit ambiguous, and he counted his own votes. So it's not nuts, but at least in the presidential impeachment, the Chief Justice presides. In 1868, Chief Justice Salmon P. Chase presided over the Johnson trial. Now, Chase was a former Lincoln cabinet member who was a rabid supporter of Reconstruction. So he actually took a very proactive role. Chase would actually break ties. That the Senate divided in half, Chase would actually cast a tie-breaking vote, which generally a presiding officer can do. Rehnquist in 1998 did not have that much power. He didn't do much at all. In fact, he said his role was to do nothing at all and do it particularly well. He didn't cast any important votes. He didn't do anything significant. He just kept things moving along. And I think that's probably the model for how Chief Justice Roberts will proceed. Roberts, of course, was a Rehnquist clerk. Although Roberts did make a little fuss the other night around 1 a.m. after I already went to sleep. The lawyers for the managers made some claim that the president's trying to cover stuff up, and then the other side said you're being dishonest, and they kind of went back and forth on the floor, and then Roberts admonished them, right? When the Chief Justice admonishes you, you pay attention, you perk up, to use language consistent with the world's greatest deliberative body, the Senate. And he had this anecdote from the early 20th century where some senator used the word pettifogging. Google that one, right? Pettifogging. And that was considered out of order. So at least Roberts is trying to keep the rules, keep some decorum in the process. Okay, now what are the rules for the Senate trial? For those of you, I think my friend over here, you know this very well, the rules are set by majority vote, right? There are no specific guidelines in the Constitution of how they proceed. In 1998, the Republicans and the Democrats largely agreed 100-0 on how they should proceed with the impeachment trial. Today, not so much. In fact, the first 3 or 4 days of the hearing was all about arguing rules. What would happen is the minority leader, Schumer, would put forward a rule, and they debate it for 2 hours, and they take a vote. And they put forward another rule, they debate it for 2 hours, and they take a vote. And there's all these rules one after the other. Every vote, I think but one, has been 53-47, which is right along the party line vote. So far we've had, I think, there was one vote where Susan Collins of Maine voted to give more time to the other side, which, I guess is important, but wasn't too mission critical. At some point, I think today is the day, maybe about, actually right now, 1 o'clock in Eastern time, the arguments in chief begin, and the House will be making their case. Now, when I say the House, what am I talking about? The House appointed what are called managers. Think of these as the prosecutors, right? And they literally walk from the House to the Senate, and they prosecute the case. The president is represented by the White House counsel, Pat Cipollone, as well as his private counsel. His name is Jay Sekulow, and he has an entire motley crew of people: Alan Dershowitz, Ken Starr, Robert Ray. He's got an entire team lined up to make the arguments for him. The House managers get 24 hours, spread over 3 days, so roughly 8 hours a day for argument. And then the president's lawyers get also 24 hours a day over 3 days, and they get their arguments. At that point, after all the arguments are made, which will probably be, my math is right, Sunday or maybe Monday, depending how it stretches out, they'll have more debates about witnesses and who comes to testify. Okay, so that's the general rule. Let me talk about the specifics of what actually we're dealing with. Over the past 3 years and change, there have been more allegations against President Trump than I can possibly count. There have been a lot. One of the first major ones concerned the Mueller investigation, which took, I think, almost 2 years of time. And the Mueller investigation concerned allegations of Russian collusion, and also whether there was an effort to obstruct justice and to cover up that collusion. Okay. The House representatives did not opt to bring an article of impeachment based on obstruction of justice. They could have, but they didn't, for one reason or another, and we can argue forever why they didn't. There was another article of impeachment that was possible they did not bring, which was bribery. The Constitution specifically spells out bribery as an enumerated offense. It's treason, bribery, high crimes, misdemeanors. The House could have brought an article of impeachment based on bribery. And the argument goes like this. The famous phone call, the perfect phone call, if you will, with Ukrainian President Zelensky, where President Trump said, hey, can you do me a favor? I'd like for you to investigate the Bidens, and we know that perhaps some money will be held up in the process. Okay. Some people might call that a quid pro quo. You give, I give, right? You give me this investigation, I release the aid. I think that article would have failed for a host of reasons, which are not important here, but they opted not to bring an article based on bribery. They also could have brought an article based on appropriations law, which is far too complicated for me to explain in a few minutes. But let me briefly encapsulate it. There's a law called the Impoundment Control Act, which was enacted after the Nixon presidency. And the Impoundment Control Act ensures the president spends money that's been appropriated. The president can't say, nope, not going to spend it. And there's all these technicalities of providing notice to Congress when you don't spend it, giving rationales and things I'm not going to waste time on. But the House could have included an article that said the president order the violation of the Impoundment Control Act. They didn't do that, although they sort of hinted at in a few places. Instead, they brought two articles that are very different. The first article is premised on what's called abuse of power. Abuse of power. What they allege is that the president violated the public trust. He abused the power of his office by demanding or asking, depending who you ask, that the Ukrainian president investigate the Bidens, and that it was an abuse of power to condition the release of that funding on an investigation. Now, if those facts sound similar to the bribery facts I gave you a minute ago, they should. It's effectively the exact same predicate offense, right? The exact same facts could have supported a bribery allegation, or they could have supported an allegation based on abuse of power. Now, why didn't the House just bring a bribery charge? Bribery has specific elements. We know what those elements are. There's a lot of jurisprudence on what bribery is, and I think it would have been harder to prove. So they effectively opted for what you might call a lesser included charge, if I can use that phrase from other elements of law. Of course, there is no statute defining abuse of power. It's a nebulous standard, which gives rise to challenging that this is far too open-ended to support the removal of a president. Moreover, critics, Josh, right, see the New York Times today, argue that the sort of behavior the president engaged in perhaps is unconscionable, but it's politics, and asking to help your political prospects, something that's done quite often. I don't want to go down that road because it'll make people angry, but I'll try and stay on the narrow line. Just read the comment thread on my Times piece. It's garbage. I had not checked my Twitter mentions today. Don't even want to look at them. They're awful. So the first allegation concerns abuse of power. And this is open-ended, and I think the concept of abuse of power does have a history. It can be an impeachable conduct, but defining it can be largely done in the eye of the beholder. The second article of impeachment is something very different. The second article of impeachment is called obstruction of Congress. Now, this is not obstruction of justice, obstruction of Congress. Just to be very clear. Obstruction of justice would have meant that the president interfered with the investigation by Mueller, right? He destroyed evidence, he told his subordinates to lie. Those sorts of things would have amounted to obstruction of justice. Congress has not alleged that. In fact, I think that would have been a much stronger article than the one they included. I think obstruction article could have actually worked in my mind, but they didn't bring that. They chose not to. So what is obstruction of Congress? Congress issued subpoenas to cabinet officials within the Trump administration. Okay. There are two categories of subpoenas that are relevant here. The first category is fairly routine. Congress can subpoena executive branch agencies pursuant to its oversight power, or what we call the legislative power. That is, Congress created these agencies, they can investigate them. And maybe Congress wants to enact legislation to regulate these agencies, they need documents. The president is fighting those, but has generally gone to court to dispute them. But the president doesn't say that the legislative subpoenas are invalid. Congress also issued subpoenas premised on its impeachment power, right? What the president has argued that the legislative subpoenas are fine, but the impeachment-related subpoenas are not okay, all right? Why? Why are the impeachment-related subpoenas not okay? There's a couple arguments. First, and this is uber technical, the subpoenas were issued based on the impeachment power before the House took a vote on impeachment. I'll say it again. The subpoenas for impeachment were issued before the full House took a vote to authorize the impeachment. So basically, they're saying the subpoenas were void ab initio, right? From the outset, they were not authorized by the process. In contrast, in past administrations, the House had taken a vote at an early juncture to authorize an impeachment inquiry. See, this was where politics and law intersect. Speaker Pelosi didn't want her members taking a vote too early because it might have been unpopular. But the committees were doing their work while this was going on. And the president has argued that the impeachment process can't trigger subpoenas until the House takes a vote. Now, there's no rule saying that, right? There's no precedent saying that. In fact, courts have rejected it, although at least one judge in the D.C. Circuit wrote a dissent that is consistent with this position, and the Office of Legal Counsel has also issued this position. All right, but they've also argued that these subpoenas are beyond the scope, that they can't interrogate the president's high-ranking national security officials. But in any event, the president's basically said, I'm asserting my executive privilege. And usually what happens when the president asserts a privilege is Congress goes to court, right? There are like 3 or 4 cases currently pending in which the House is litigating against the president's administration to enforce a subpoena. Let me pause for a second. The Supreme Court's never blessed this, right? The Supreme Court's never actually held that Congress can go to court to enforce a subpoena. There's argument on that question in March. I don't have a strong opinion on it. I thought about it, and I don't have a strong opinion on it. But usually Congress goes to court to enforce subpoenas. But Congress did not go to court to enforce these subpoenas. In fact, one person who received a subpoena, his name is Charles Kupperman. He went to court and so it was effectively a declaratory judgment saying, Judge, do I have to comply with the subpoena, right? One guy said, I got the subpoena, Judge, you have to comply with it. What did the House do? They withdrew that subpoena. They did not want the courts testing whether the subpoenas were valid. Oh, right? They didn't want the courts testing it because they knew they probably would lose. So instead, they just issued the subpoena. Trump said, no, come sue me. And then they said, okay, we'll impeach you instead. So this creates a weird dynamic where the president's saying, my assertion of a privilege is now the grounds for impeachment, right? The fact that they won't comply with any impeachment-related subpoenas is itself within the constitutional authority. I have the power to issue to assert a privilege. If you want it, you challenge my privilege, you litigate it. And the House refused to. This, I think, is a much weaker article of impeachment by far. Again, the important point is the president is willing to litigate the other legislative subpoenas, but not the impeachment-related subpoenas. There was an article in the Nixon process on obstruction of Congress, because Nixon also refused to comply with congressional subpoenas. In that case, there was a vote when the subpoenas were issued. I think there's a distinction. I don't know the right answer. I think it's not entirely clear, although the Supreme Court will address this issue somewhat soon. But let me just make this point a little bit more indirectly. The House took shortcuts. They didn't bring a bribery charge because that would be too hard to prove. They didn't bring an obstruction of justice charge because that would be too hard to prove with Mueller. They did not take a vote early on, which I think weakens their obstruction of Congress claim. I think the strongest one they have is abuse of power, and I think that's something that reasonable people can disagree on. So effectively what we're left with is a vote that's, in my mind, what you might call a vote of no confidence, right? If you have any sort of organization saying we don't have confidence in this president anymore, that's what the abuse of power amounts to. And if abuse of power is effective voting of confidence, then I think we're moving more towards a British system where they have a new prime minister every 5 minutes, rather than something with a fixed term of office. Again, I'm not a Trump fan. People use every label they can. I'm not a fan of his. I actually criticize him at some length. But I think that the process taken here does have some shortcomings that could come back to bite any politician in the future. Okay, so what happens next? We have a vote in the Senate. I'm sorry, we have a trial in the Senate where the House managers present their argument in chief. The president's lawyers present their argument in chief. And at that point, you have a process by which the senators can ask questions. Now, what's fascinating about this process is the senators cannot say a word during this process. They have to sit there in absolute silence watching. Now, the cameras, this is a fun part, the cameras in the Senate are not trained on the senators. The cameras are focused on the lawyers. So we have no idea if the senators are there or not. We have no idea if they're sleeping or not. In fact, there's been some reports that senators are asleep in the gallery. I don't blame them. They're actually not even allowed to drink coffee. The rules say water or milk. Why milk? I think the ag lobby has a very big influence. You think I'm joking. There are 23 ag states, so I think they got the milk in there. But you can't even drink coffee. They were in the chamber for almost 13 hours on Tuesday night with only a few breaks. And God bless Chief Justice Roberts. He pulled 2 hours of the Supreme Court from 10 till noon. The trial began at 1 p.m. He was there until almost 2 a.m. He was back at the Supreme Court the next morning at 10 a.m. for 2 arguments. Respect, that's remarkable. Anyway, so after the case in chiefs are presented, each senator is allowed to present questions, but they can't say the question out loud. The questions have been put in writing, and it's basically read by the clerk, right? So you pose questions to the one side, you pose questions to the other side. Eventually, when all the questions are resolved, and I'm not sure how long that will take, it's somewhat of an unknown, you have a deliberation process. Now, in this regard, the Senate operates like a jury. Generally, where does a jury deliberate? You sequester them, right? You put them in a closed room. When the Senate deliberates, the cameras are turned off. Only senators are allowed to be in the room. This is a point of huge controversy, right? No C-SPAN. C-SPAN doesn't have cameras in there. There's Senate cameras, and the Senate turns them off. The Chief Justice is gone. The lawyers are gone. Only the 100 U.S. senators sit there in their desks, surrounded by each other, and deliberate. And we have no idea what's going on there. Isn't that remarkable? Then, in the year 2020, you have a debate about to remove the president. We have no idea what they're saying. There was Floyd Abrams had an op-ed in the New York Times about this, probably more popular than mine, arguing that they should open up the proceedings. I like Floyd as a friend, but they should open the proceedings. All right, and then what happens? They take a vote. They're actually going to take 2 votes, right? They vote on Article 1, which is the abuse of power standard, and then they vote on Article 2, which is the obstruction of Congress standard. To convict, you need 2/3, which basically means 67 senators on each article. If 2/3 is reached, the president, in my mind, is removed automatically. Some people argue you need a separate vote on removal. I don't think so. I think once you convict, the president's out of office, in which case the vice president would take the oath immediately. But there's a second vote that can be held. The Constitution says that a person who's convicted can be disqualified from holding certain federal offices in the future. That is only a majority vote. So for example, we've had some federal judges who were impeached and disqualified for bribery that they can't hold certain positions in the federal government again. That's a simple majority vote. If the president's impeached, the vice president becomes the president. What happens to the vice president? Well, the position's vacant. The president who was the vice president, which say Mike Pence to make it easier, could then nominate a new vice president. And the Senate and the House would have to confirm that new vice president. Sort of a weird wrinkle. If they confirm no one, the vice president position remains vacant. We don't need a vice president. We've actually had extended periods in American history with no VP. It's a worthless position. It doesn't really do anything. Unless the new president also dies or gets removed, and then the speaker elevates up to the presidency. Now, I'll let you know, some scholars think that that's unconstitutional, that the speaker as a legislative officer cannot become president. I disagree. I think he can, or she can in this case. But there's a debate about whether our succession statute is even constitutional. I think the speaker would be perfectly fine to serve as president, but unlikely to happen. Okay, so where does this all lead? We're in the middle of this process. I don't need to ruin the ending, but I think you all know there will not be 67 votes to remove President Trump. It's not going to happen. So I think we'll have the end of this trial 2 weeks, maybe 3 weeks if I had to guess. It's hard to predict, but I'd say by Valentine's Day we're done. But that doesn't stop them from impeaching him again. And I think there's a good chance if President Trump wins re-election, we have another impeachment trial on God knows what else, just other stuff. My fear, and I don't say this lightly, is that this becomes a permanent feature of our political order, where whenever the party in power is one and the Congress is in the other, they hate each other and they just turn to impeachment. And there's lots of things. I mean, every president has done things that can be considered an abuse of power. All of them. All of them. Let me give you a really egregious example, right? The allegation against President Trump is that he tried to use his office to investigate his opponent, which would help in the election. Describe it however you want. Let me tell you a story about President Lincoln, what he did. During the height of the Civil War, an election was being held in Indiana. And the Republican Party, the party of Lincoln, was on the fence because the Hoosiers weren't sure what they wanted to do with the election. And it was unclear if the Republicans would retain Indiana. What did Lincoln do? He wrote a letter to William Tecumseh Sherman, his general. He said, General Sherman, would you be willing to release soldiers from Indiana to go home so they can vote for the Republicans? Just think about that for a second. You were taking troops off the front line, risking lives to ensure that one political party retains office. Now you say, oh, that's different. He was saving the nation. I got it. Trust me, I get that. I get that. I'm with you. But at bottom, it's a judgment of what is the correct public good, right? What should the country be doing? And that's something which I think uniquely the president's elected to do. I think an investigation of Biden's been a waste of time, but that's not my judgment call of what is in the national interest. Let me give you one other anecdote. President Johnson, in 1967, he wanted to nominate Thurgood Marshall, the great icon, to the U.S. Supreme Court. But there was a problem. There were no vacancies. So what did LBJ do? You know what LBJ did, right? So he said, I got an idea. One justice was Tom Clark, who was getting a little bit older in age. Johnson appointed Tom Clark's son as Attorney General for the sole purpose of conflicting out a justice, knowing the justice would have to retire, right? If you have the Attorney General as a son, the father would have to recuse in half of his docket. So he retired. And once he retired, Johnson put Thurgood Marshall on the U.S. Supreme Court. Man, that was a popular move. Totally corrupt. I mean, he basically tried to engineer a conflict of interest. I mean, I'm trying to think of an analogy. That's like, one of your law firms, right? You're on a trial, and you basically hire the spouse's son for your counsel team to try and recuse out a judge. Can you imagine doing that? Right, you're in the middle of a trial, and you find the judge's son, you make him a partner on your trial team to try and conflict out. I think you probably have a bar investigation for that. I don't know, maybe, I don't know. You guys, you're the Bar Association, you tell me. But my point is, presidents do stuff to advance their political interests all the time that are very shady, that are very disingenuous. Now maybe say, wait a minute, Josh, this is involving a foreign power. I get it, Josh, I get it. The president has powers there too. There's only one person in the United States who can ask a foreign leader to do stuff, and that's the president. No one else can do it. I mean, maybe the secretary with authority, but that's the president's power. He makes communications with foreign leaders. And if there actually was some corruption, and I don't think there was, but I'll just entertain it, it was a reasonable request. What makes it so disturbing is a person being investigated is the vice president or the former vice president who's now the president's opponent. I think that's why people have the reactions they do. My bottom line is not to tell you that the impeachment is good or bad, but the standard being used here, this abuse of power, I think has risks for the future. Moreover, and I think this is an important point, we're not done with this, right? We went nearly 100 and something years without an impeachment, another 100 years without one, right? We've now had 2 in 3 decades, right? This will become much more common. I think it's divisive. I think it rips apart the fabric of our country. I don't think anyone will be happier for it. I think when President Trump when the trial's over, no one will be happy. Everyone's gonna be upset. People are still gonna be angry. And we'll have an election a couple months later. So let's vote. Thank you very much, and I welcome your questions. Yeah. Well, so in most, and I'm not an expert, but I'll briefly describe it. In most parliamentary countries, you have not an election every 4 years. You have what are called snap elections. In other words, when there's something going on and the party in power has some crisis, you have an election in the middle of a year. And that effectively operates as a vote of no confidence on the sitting prime minister. So with Brexit, for example, we had Theresa May, and her actions were considered not very popular, so she stepped down. Now you have Boris Johnson, right, as a new PM. For those of you who follow Israeli politics, they've had, I think, 3 elections in the last year for prime minister because they can't get a majority of the parties to agree. We don't have that system. That's not the system we've set up. Maybe we should, right? Maybe we should be able to take a vote of no confidence and instead of every 4 years whenever there's some sort of dispute in Congress. I don't know if that's better or worse. I can argue forever, but that's not the system. You're probably familiar with the phrase, it's better that 10 guilty men go free than 1 innocent man go to jail. We all know this phrase, right? I kind of think it's better that 10 guilty presidents stay in office than that 1 innocent president doesn't leave, right? I think if we start impeaching left and right on a presumptive basis, we'll go down a path that doesn't lead to a good country. Yeah. Yeah. I wish I knew. They're old rules that probably were never updated from a very long time ago. I think the short answer is the Senate trial is considered confidential in ways that most Senate proceedings are not. The fact that they can actually close the door and shut the cameras off is an anomaly. I think these rules are designed to prevent anyone who's not supposed to be there from being there. The senators can't have their phones on the floor. In fact, some senators have their Apple, their iWatches, and that was a no-no. They kind of got in trouble with the sergeant at arms. We even had a protester the other day who managed to get into the gallery and was making a ruckus. People can sit, on the bleachers, but I'm guessing the milk one is because the ag states want to make sure that they agriculture, right? But I don't know the answer for you. It's a very weird rule. Yes.
So, my understanding is earlier in the Republic, after saying kind of the populace saw kind of a routine tool, like
Mhm.
so I guess we can take a less pessimistic view of this, we improve it,
Yeah, so I acknowledge there's one perversity of my position, right? Impeaching a judge, all right, no big deal, right? I mean, it's a big deal, but there are plenty of judges. Look, if there was a district judge named Porteous who was removed, does anyone even remember anymore? I mean, that was a huge thing like 15 years ago. Does anyone even care anymore? He was removed from office? Is it Porteous? How do you say it? Porteous, I'm sorry. Judge Porteous, I'm sorry. I never said it out loud. But the president's a pretty big deal. We've had 44 or 45, depending on how you count, right? We've only had 40-odd presidents. And removing one is a huge seismic, cataclysmic event that ripples. So perversely, I am less troubled by removing a low-level district court judge in this region than removing the president, which is bizarre because the president has a lot more power than a single district court judge. And I recognize my position is somewhat perverse. I acknowledge that. Yes, right over there.
So how does this Senate distinguish, if at all, like voting on conduct and articles versus whether he should like whether he actually did the thing?
Uh-huh. They rise to level, right? Right. So it's almost like a fact question and law question, right? Juries generally find facts, but they give instructions of it if you find these facts. That's not here. It's all mixed, mishmash together, right? A senator could say, I am voting to acquit because they didn't find the facts. Or a senator could say, I am voting to acquit because they found the facts, but this legal standard is not appropriate. It's basically nullification, right? And I don't want to say this lightly. Usually, if you're criminal defense attorneys, nullification, usually you can't get that instruction in court. That's just not allowed. But a senator can absolutely nullify, saying, this impeachment, abuse of power, that's not a real thing. I'm going to nullify, right? I'm going to vote against the articles themselves. Even assuming the facts are as pleaded, it does not rise to level. And that's generally my position. I accept the facts mostly as this House has presented them, but I think just what they've defined doesn't meet the threshold. Yeah, in the back.
My question concerns the language of the Constitution that deals with removal from office versus disqualification for future office. Is that predicated on what the articles of impeachment, or is there guaranteed to be a separate vote? Because you said 2/3 convict, remove,
Right.
but simple majority
Yeah.
So if they can't get
They don't get to the second vote without the first vote. Yeah, I mean, wouldn't that be fun, right? You only get to disqualification if the person's removed. Yeah, wouldn't that be fun, right? No, you only get to the disqualification vote if you get the removal vote. And there have only been, I think, like a handful of disqualifications in American history. It's very rare. My general position is, if the people want to re-elect a convicted person, let the people decide. I know it sounds insane, but we've had people who've come in and out of jail and been elected back to office. I generally think let the people pick. Yeah. Oh God, I don't know. Really, I'm not watching I said let me watch it, but I can't. It's the same thing over and over again. I mean, you could do this in a couple. You could try this case in a day if you really wanted to, but you get 2 hours debate, 2 hours this. They're going to repeat the same thing over and over again, right? The allegations are so well understood that there's going to be a lot of repetition. If there are witnesses, though, I modify my position. Witnesses will take up time. Now, don't get your hopes up about witnesses, right? How many of you are trial lawyers, right? How often do witnesses drop bombshells at trial? Okay, maybe it happens. But in a case like this, coached. They're going to be coached. They're not going to say anything shocking. They're going to say what they need to say. I don't think that witnesses will blow this trial up. Maybe we'll learn a few things new. Maybe John Bolton will sell some books. I don't know. Right? Hunter Biden will talk about his family life. I don't know. Oh, sorry. That would be a very long testimony. Yeah. Yeah.
First, about the subpoenas.
Yeah.
If your point about the invalidity of the impeachment-related subpoenas, if there hadn't been a formal vote to initiate
Either. Neither vote was taken at that time.
So it was premature for the committees to
Yes.
conduct investigation
Yes.
in issuing subpoenas.
Yes.
And what's the basis for saying that they didn't have authority to investigate when the Justice Department declined to investigate?
Well, other subpoenas were based on oversight, and the argument I'm giving doesn't apply to that. The legislative oversight subpoenas are in a different category. Those have been litigated in court. But the impeachment, in other words, when you issue a subpoena, the very first page says, here's the basis for the subpoena. The ones where they said the basis is impeachment, those have not been tested in court. Right? Those are the only ones that this argument is being applied to.
But the Supreme Court in the Nixon case didn't put the subpoena by Leon George.
It was part of the criminal trial, right? Yeah, let me address this. It's a good point he raised. Right, during the Nixon case, right, we all remember the Watergate tapes. Who wanted the Watergate tapes? They were not actually needed for the impeachment proceeding. They were needed instead for a criminal trial where Leon Jaworski, who was a special prosecutor, was charging Nixon's accomplices. And the accomplices said, we have a Sixth Amendment right to production, compulsory production of evidence. The Nixon associates wanted the tapes for their defense. They wanted the tapes for their defense to show that we weren't alone, that the president was involved, to kind of mitigate their guilt. So it wasn't the Congress requesting the tapes, it was the criminal process requesting the tapes, and there's a constitutional Sixth Amendment right to production of evidence. So the Nixon precedent doesn't really help the House here. I mean, it's in the ballpark, but it's not on all fours. That's correct. Yes. What is an unindicted co-conspirator? It's not a thing. I mean, people say it, but it's not actually. I don't know. It's not actually a thing. It's just, we haven't indicted you, but you're indicted. Go on. Yeah. Yeah. Yes.
I don't think it's a meaningless term.
Yeah.
I think it's a handy term
Yeah.
to describe the character or the status of the person who's not being tried.
No, I agree.
And I guess the second question has to do with the fact that at any point now, the senators could vote to subpoena Hunter Biden. There's nothing stopping them from voting to subpoena him now. Regardless of whether or not any other witnesses they have the power to make the Constitution. And the fact that they subpoena witnesses call them to subpoena some vote. So why is that not political?
Right. So the question of calling witnesses is twofold. One, when do you do it? And two, should you do it? Right. So should they? It's unclear, right? There's one argument that it's the job of the House to put together a factual record. Generally, that's how trials work. But the House called no witnesses because they were in a hurry. They wanted to get this done by Christmas. But the question is when? Do you call witnesses at the beginning of the case in chief, or do you call witnesses after the case has been submitted? Right? You might argue that in most trials you call witnesses during the case in chief before the evidence has been closed. But there's some senators who want to call the witnesses after the case has been submitted at the very end. I don't have a strong opinion on whether Hunter Biden should testify. I think it won't add anything to the proceeding. I think it'll just make it more circus-like. Because if they call Hunter, they call Joe also. I think that's called both of them. And you know, I think I don't see the value. You call John Bolton or Mick Mulvaney, they're not going to say anything useful. We've seen members of the cabinet sit for congressional investigations. Those are not very productive conversations. I think they'll operate in the exact same fashion. I mean, I suppose the Senate could hold Mick Mulvaney in contempt and lock him up in the Senate basement. I guess they can do that. But, you know, it's unlikely. There's also one other fun issue. Can a cabinet official subpoenaed raise executive privilege in a Senate trial? Because if a cabinet official is testifying before Congress, they can raise privilege, at which point you have to litigate it. Can they raise executive privilege in a Senate trial? I don't know there's a clear answer to that question. Yeah. Yeah.
At least on TV, what I hear them saying is, the president hasn't invoked executive privilege. The president has done is invoke absolute immunity. It may apply to Joe Kavanaugh, but absolute immunity doesn't prevent all of the lower level people who actually came and did testify, 17 witnesses, some of them from the district, who actually did come and testify. So I didn't hear any claim of executive privilege
Yeah, I think the claim of executive privilege, absolute privilege, bleeds into the allegation that the impeachment subpoenas are void ab initio. I think there's a bleeding in. OLC, the Office of Legal Counsel, wrote a 30-page opinion on this question, which I commend to your attention. Agree or disagree, it states position much better than I can. Thank you for the questions. Yeah, in the back. I don't think there's like an NDA. I mean, I can't imagine that they're barred from speaking about it. I think they'd be able to. You know, it's like, you know, in the papal enclave, right? When they're selecting the pope, they're all sworn to secrecy except when all these accounts come out. So I think that, oh my God, when that trial lets out, there's gonna be a run to the microphone. It's gonna be, you know, just get out of the way. Don't, you know, just don't get out of the way. It's gonna be like a sprint. They're tweeting, right? Yeah, Haley. No, I think, well, yes, I think you would, because perhaps you could disqualify one, not the other. I think you'd have to do both. I think it's, you know, I mean, he's removed, but I think you'd have to consider both articles. Yes, ma'am. It's a really good question, right? Generally, with a jury trial, you're fixed to the four corners, whatever's in the record. It's not clear if evidence created after the impeachment articles are fair game. But to be frank, the senators can't be told how to do their job. If they want to consider Rachel Maddow show, they can do that. And I don't see any reason to stop them. I think the better allegation is, you know, the GAO report decision, for example, which I can talk about maybe later if you want me to, that was only issued the day before the impeachment trial started. Is that fair game to consider? And again, I think the senators can follow their conscience. They don't have rules. In other words, there's no sequestering, and there's no judge telling you, forget everything you know, don't look on Facebook, don't look on Twitter. They're going to do that. They are. So it's a mistake to try to make this too much like a formal criminal trial. You'll lose it very quickly. Yes?
During their case in chief, this 24 hours trial,
Yeah.
did this come to argument the whole time, or did they actually ever go back to fill in some of the evidence there, or some of the deposition testimony, or are they just going to tell us that they think it all says? That seems to me it's just an opening argument for 24 hours.
Basically. Yeah. It's basically a 24-hour opening argument with no witnesses, right? And I mean, their opening argument has PowerPoint, right? They're playing clips of video. They're playing, you know, excerpts from transcripts. They're reading from the perfect transcript, right? I mean, if you ever want to have a deposition, a depo transcript that's perfect, that's the perfect one, right? But yeah, it's basically it's a 24-hour opening argument. I think that's a good analogy. There's someone else. Oh yeah, in the back, yeah. Ooh, that's a hard question. So I mean, let me take your question for a minute like this. John Bolton gets up there. They ask him a question. They say executive privilege. I'm not answering, and then the House files an action in the District Court of District of Columbia, and that gets appealed to the Supreme Court. I think Roberts has to recuse. One or the other. Can't do both. So basically, the D.C. Circuit gets with a 4-4 tie. I've thought about that hypothetical. It scares me. The better question is, what if Roberts is not able to preside? Can someone else preside in his place? I think the senior associate justice could. That'd be Justice Thomas. I think it's unlikely, but yeah, in the back. And I got about 4 minutes left. I'll get you over at one, but maybe 1 or 2 more questions. Well, he could rule on the chair. I think her question was, what if he rules as Chief Justice in the Supreme Court? Right, like you have a Supreme Court decision. I think he'd probably have to recuse from that proceeding, which, I mean, not, you know, what a mess. Yes. Yeah, I think it's basically, well, Bolton's a former official, so that's a little bit different. Bolton's former, Mulvaney's current. Right? So basically, Trump can assert it for Mulvaney because it's a current person. He can't assert it for a former official, but the former official can raise it saying, this was something I discussed in deliberative privilege. Same way, you know, if any of you have a client that relationship severed, you can raise privilege in a future proceeding, right? Because you had that relationship at the time. Oh God, I didn't even think of that. Yeah, I guess you could. I mean, I don't. I think if Joe Biden, as vice president of communications with the Ukrainian whatever, I suppose he could raise privilege. Why not? Give John Roberts another case to decide. I mean, this just gets so messy, which is why the entire obstruction of Congress article is so closely intertwined with the courts. It's hard to unravel that. Yes.
Given that the way the trial proceedings is 24 hours, that's not what
No.
the trial. Is there any scholarship about the trial,
You know.
something about how this
Well, the short, and I always love talking about originalism. The short answer is the Constitution says the Senate shall try, and that means the Senate can try based on their rules, and the rules are what a majority says. You know, what if the Senate just moves to dismiss the articles outright? During the Clinton impeachment, Senator Byrd of West Virginia moved for a motion to just dismiss the articles outright, not even go to a verdict. It didn't get enough votes, but it was introduced and it was ruled in order. So I think you could have a motion to dismiss 12B6 it right away. I think you could. I think it would be a good idea, but you could. Anyone else? Maybe one more question? Ooh, it's loud. His administration may have. I don't know that he did, and that's actually an important difference. The ICA doesn't control the president directly. It controls various people with an OMB. If you read the GAO decision carefully, it says the OMB violated it and the president didn't faithfully execute the law. They're very careful how they phrase that. The president may have violated his oath of office if he directed his subordinates to knowingly violate the ICA, but issuing an order that he thought was lawful, I don't know that violates his oath of office. Short answer. Okay. Anything else? Thank you all so much. Let's go to class now.
Here is a token of our
thank you.
appreciation. And
Thank you so much.
Really, very interesting topic and very timely.
Thank you.
For
Thank you.
coming to talk to you. I know your 2 o'clock lecture on oil and gas will be just as interesting.
You're a blast. Thank you.